As we reported Monday, California has now become the fifth state to legalize a so-called right to die law, giving patients with terminal illnesses the choice of when to end their lives. In order for a patient to use that law, they must have less than 6 months to live. 2 doctors must sign off on the patient's lethal dose of medication, and the patient must administer the drugs themselves. While advocates are celebrating the decision, it raises a host of legal questions that have some people concerned about the long-term implications of the law. Troy Slaten is an attorney, joins us now for more on this story. Okay, when we're talking about the legal ramifications, who's most at risk for a law like this when a patient goes to use it?
Well, opponents of this statute argue that it's the poor, it's the disabled, it's the mentally ill that are most at risk. And the fear of these opponents is that these people have the least amount of access to high quality medical care, and therefore the option to end their life might be something that's even encouraged by their healthcare provider in order to save on healthcare costs.
So can you see a scenario where a person chooses, ostensibly, to end his or her life? The family then sues the health care company, the health insurance company, saying you pushed them to do this?
There are a lot of exceptions in the law, and the doctor has to certify that the patient that he's treating does not have mental illness. If he does, the law requires, it says that he shall refer the person to mental health professionals. And if he doesn't, that could subject the doctor to civil and criminal liability.
Okay, then what happens when a mentally ill person, someone who's struggled with mental health issues, also has a terminal disease?
It would be up to their mental health professional to certify that they are of sound mind and able to make this decision. It's important to note that if a person does have a mental disease or defect and they're under a conservatorship, which means that another person is responsible for them, like a power of attorney, that person cannot authorize death under this statute.
Who else might suffer in terms of the kind of discrimination the law unintentionally promotes? I mean, is there going to be issues about poverty-stricken patients as opposed to those who have a lot of access to wealth?
You know, opponents of the bill argue that, but it's important to note that California is not the first place where we're seeing this in action. If we look to Oregon, the status quo really hasn't changed. We're just not seeing the parade of horribles that opponents of the bill suggest could happen.
Troy, nice to talk to you. Thank you.
Thank you so much.